tonight, our speaker is Christine Svenson, legal counsel for Judicial Watch here in Illinois. I happened to hear her speak. I was on the radio with Aaron Delmar for AM 560. He was filling in for John Anthony, and she spoke before me, and I'm like, oh, I need to get her for a speaker. Christine will speak about voter integrity and free speech issues. She will specifically talk about the pending case in front of the Supreme Court of the United States, Boss versus Illinois State Board of Election, along with another pending case involving a local high school teacher who was fired for her conservative Facebook posts. Please join me in welcoming Christine. Thank you for joining us.
Testing. Does that work? Thanks, Debbie. Thank you so much. So it is such an honor for me to be here. I really appreciate your group. I've been following your group. I've been getting the emails for a few years now, and now I actually get to attend and participate. You guys do phenomenal work. So I'm very honored, again, to be speaking to you all tonight. I would like to recognize some friends, family, clients, before I delve into the issues at hand. So I have my mom, Judy Svenson, here tonight. I have other family, Kevin and Sheila Fitch. They live in St. Charles. They're nearby. And I actually have former clients. I have current clients. I am going to be talking about my current clients. I don't know if my former clients, some people don't like to be recognized, but if you're a former client and want to stand up, feel free. You don't have to. You don't have to. That's Brian McCann and Chris Reese. I have two current clients here, Carol Davis and Susan Sweeney, if you'd like to be recognized. And we'll be talking again about their cases shortly. So let's see. I want to make this a little bit interactive. How many of you, I have an attorney friend here too now, Marie Sarantakis. Actually, how many lawyers are in the room? I'm curious about that. Lawyer. Okay, good. It's just kind of, my mother's a lawyer too. You can raise your hand, Mom. So, where was I? How many of you have heard of Judicial Watch? Oh, that's incredible. That's so unbelievable because they started out, they are what I would consider a government accountability law firm. They're based in Washington, D.C. They got their start about 30 years ago. This is all on their website, but I mean, essentially from mail campaigns, they solicited, in a legal way, for donations and built up a non-for-profit law firm that is unquestionably, they've done the most amazing work for our cause, the conservative cause, of any group out there in the entire country. There's no question about it. So they do, in the way they do that is they pursue records under FOIA statutes or whatever, which means Freedom of Information Act, whether it's at the state level or the federal level. They're able to uncover records that we never could have dreamed of. This is the most incredible thing they've ever done. They actually were the ones, Judicial Watch actually discovered Hillary's server. That's true. Hillary Clinton would have been president in 2016. There's an argument for that had it not been for Judicial Watch. So that aside, I get to do their local work here in Illinois. So not only are they seeking records, they also want to hold the government accountable in cleaning voter rolls and having clean elections and ensuring that government employees, their free speech rights are protected. And there's a few other miscellaneous areas that they handle as well. So I'm going to talk about three distinct areas. The first is the Supreme Court case. I'll explain how we actually got to the Supreme Court. And that case involved, as we all know, the absurd Illinois state law that was passed around 2005, about 20 years ago, that allowed ballots to be counted and posted 14 days after Election Day, if you can believe that. We all know this. It's one of the most egregious examples of, allowing for and inviting voter fraud, right? So, in fact, let's delve into that case. So next screen, if you could. Okay, actually, I'm going to stand on this side so I can read it better. So again, this is Judicial Watch coming up with these ideas, and I'm the local counsel who gets to sort of assist. This was a bit of strategery, right? I mean, they go all over the country and look for state laws that are superseded by federal laws, and our Illinois law was one of them. So in May of 2022, we have 3 plaintiffs. We have a sitting congressman, Mike Bost of the 12th District. He's downstate, federal congressman. We have our friend Susan Sweeney, who's was and still is a federal elector, presidential elector. And Laura Palestrini also was a presidential elector. So they were federal electors. We sued the State Board of Elections, Illinois State Board of Elections, alleging just what I said, that our ballot receipt deadline is preempted by the U.S. Code and is unconstitutional under the 1st and 14th. So these are the specific laws that we cited in our complaint. We'll get into it a little bit more. Violation of the right to vote, violation of the right to stand for office, violation of, that's allowing, we'll get to USC 7, okay. Yeah, I already discussed this. They changed its practices in 2005. We can skip to the next. So I just found this interesting. I know it's hard to read, but the Illinois State Board of Elections, before the crucial November 2020 election, they issued an advisory saying that the number of ballots received after Election Day, so Election Day was what, November 3rd, this all the way through November 17th, could materially affect the unofficial election results. They admit it. They know it. It's all by design, right? Okay, well, and again, I'm going to talk about this some more, but what is the harm in allowing these ballots to be counted 14 days after Election Day? I think everyone in this room knows, but I'm just going to, it invites voter fraud. It dilutes the vote of somebody who's actually voting legally. And there's all the harvesting. These candidates themselves are suffering an injury because they have to have campaign staff and poll watchers, and because at these clerk's offices from November 3rd to November 17th, you have to have someone watching the ballots come in after Election Day. So they have to hire workers. Again, there's a lot of expense associated with this extra 2 weeks that the candidate has to incur that cost. Okay, so this is just kind of fun. The Constitution, the history of elections. There is this balance that Congress has with the states insofar as administering federal elections. So the Constitution allows state legislatures with the initial responsibility to set the mechanics of elections to federal offices, but the Constitution grants Congress the ultimate authority over federal elections, including, quote, the power to override, unquote, most state election regulations and provide for uniform federal rules for federal elections. So you can see where there's this tension between the state and the federal. We'll keep going. Article 1 of the Constitution, the times, places, and manner of holding elections for senators and representatives shall be prescribed in each state by the legislature, but the Congress may at any time by law make or alter such regulations, which they do. We'll keep going. The Congress may determine, again, this is going back to, I believe, the 1700s. The Congress may determine the time of choosing the electors. I didn't misspell that. That's the way it's spelled. And the day on which they shall give their votes, which day shall be the same throughout the United States. After the Civil War is when Congress said the House of Representatives, the voting for the House was the Tuesday next after the first Monday in November in every second year. Next slide. So the early years of our republic, elections were conducted on a single day. and received in person. Absentee voting began to develop during the Civil War when the military were allowed to cast their ballots at their battlefield units and have them counted back home. So then the Congress decided they had to set some more national rules for federal elections. Next slide. So, Seventh Circuit. I think I skipped there's more slides. Let me explain a little bit of background more about the case and the Seventh Circuit and the Northern District of Illinois and all that good stuff. So, how many of you are familiar with how the federal court system works? Just out of curiosity. Okay. So we had to file our lawsuit we chose the Northern District of Illinois. The State Board of Elections has an office in the Northern District. And we were unsuccessful at the district court level. And so we had to appeal that ruling to the Seventh Circuit. The Seventh Circuit oversees the Northern District. It's called the Seventh Circuit Court of Appeals. A little way of background about the federal court system. There are 13 federal circuits. Again, we're the seventh. The seventh is comprised of Illinois, Indiana, and Wisconsin. So we were automatically, drawn up to the Seventh Circuit. And the Seventh Circuit also, let's just be real, they don't like our case. And they can find ways to deny us the right to pursue our case. What they do is, and this is very, very common throughout the country, they claim that our plaintiffs, our three plaintiffs, remember, a sitting congressman, 2 federal electors, presidential electors, do not have what's called standing. Have any of you heard about the concept of standing in the legal world? So, in the sort of a layman's term, standing means that you have a causal connection to the case, that you have been injured yourself. It arises out of that cases in controversy language in the U.S. Constitution. So you can't sue somebody if you're not injured. That makes sense, right? So there are various ways of finding that plaintiffs who sue are not injured, and so we're going to deny you the right to pursue your case. And that's what happened here, like I said, both at the district level and at the Seventh Circuit. So the Seventh Circuit said, first of all, that our lawsuit was too speculative because it was too hard to determine what was going to happen in the future. You could say that about any election, right? It's kind of a throwaway argument. Then we also brought up our plaintiffs have had quote-unquote pocketbook injuries, as I described before. You have to have manpower. You have to run elections 2 weeks after Election Day. When I say run elections, the election's still going on because ballots are still being counted, right? So, again, the manpower, the sweat, the blood, the tears, getting people to the polls, the clerk's offices to watch the monitoring of the votes. So they also, the Seventh Circuit looked at Congressman Bost and the size of his victories in the past, which is irrelevant, frankly, because even if his voter tally is diminished, that's an injury. It's really irrelevant for them to look at the size of his victories, but that's what they did. Next slide. Okay, so I sort of went over this. This is the cases in controversy language from Article 3, Section 2 of the U.S. Constitution, and that's how the standing doctrine has arisen out of that. Am I going too fast, by the way? Okay, good. Next slide. Yeah, I spoke about this. Next slide. I spoke about this. Yeah, and again, the majority took judicial notice of his 2022 election results. So it's speculative whether or not the counting of ballots received would cause him to lose the election. That's irrelevant. If his tally goes down and the votes are diluted, that's an injury. Next slide. All right, so here were, and that was essentially our arguments. And this is probably taken right out of our brief. The cost Congressman Boss will incur to monitor ballots after Election Day gives him a personal stake in this dispute and a basis to proceed in federal court. He had to, as I said, recruit, train, assign, and coordinate poll watchers and keep his headquarters open for an additional 2 weeks. These costs are concrete, particularized, and imminent. That's the fancy language you have to have in these briefs. Okay, next slide. Yeah, and again, candidates have an obvious interest in the lawfulness and fairness of the rules that govern elections. They have an obvious interest to ensure that the final vote tally accurately reflects the legally valid votes cast. So, we got to the Supreme Court of the United States, and that is no easy feat. We're going to go into how that happened. So, the Supreme Court of the United States takes between, what do I have here? Receives 7,000 to 8,000, it's called petition for writ of certiorari, but it grants and hears oral arguments in only 70 to 100 cases. I mean, you probably have a better chance of being an NFL star than that. Next slide. So this was our specific question that we asked in our petition for writ of certiorari. I just think it's kind of nice to see the language. Whether petitioners as federal candidates have pleaded sufficient factual allegations to show Article III standing to challenge state time, place, and manner regulations concerning their federal elections. Next slide. So before I go to this one, so our issue before the Supreme Court right now is extremely narrow. It's just about that standing issue. It is not about the merits of our case. We are not there yet. So the Supreme Court, when we're in front of them on October 8th, will not be hearing the merits of our case as far as whether or not federal law supersedes our state law, and state law should be thrown out for allowing the ballots to be counted 14 days after Election Day. That will be heard a different day if we win in front of the Supreme Court on October 8th. Why did the Supreme Court take our case if so few cases are taken by them? Well, we had a couple of what we call circuit splits. Again, we're the 7th Circuit, so the 8th Circuit and the 5th Circuit. The 8th Circuit is like the Minnesota area, a few other states, South Dakota, you can figure out what they are. The 5th Circuit is Louisiana, Texas, Mississippi, okay? So those courts held differently than the 7th Circuit. The Supreme Court is generally not interested in accepting a case where all the circuits follow the same law, right? So we have this diversity of opinion, and they're willing to take it. So in 2020, the 8th Circuit in Carson v. Simon held that, this is sort of on the merits, but still, the 8th Circuit agreed that the extension of the deadline for ballot receipt likely violates Article 2, Section 1. Next slide. This case, 5th Circuit, this was this about standing? Yeah, this is a standing case, and the court held that the Texas Democrat Party had direct standing, and they looked at the economic loss that they would suffer. Next slide. And this was one of my favorite cases because this was, again, a lot of strategery. This is a new case. Republican RNC versus Wetzel. This came out of Mississippi. In this case, the facts are so similar to ours because the Mississippi state statute had allowed the ballots to be counted up to 5 days after Election Day. This we won, meaning the RNC won on the merits of it being struck down, meaning the 5-day, allowing of the ballot. That was struck down. They didn't even challenge standing in this case. They had standing, so why don't we? Next slide. Oh yeah, the court rejected the Mississippi's mailbox rule that would consider ballots cast when mailed rather than when received. Next slide. So this is the specific relief that this is at the end of our brief to the Supreme Court. We are asking for the Supreme Court to reverse the 7th Circuit by holding that Congressman Boss' pocketbook injury is directly traceable to the Illinois statute he challenged, or that he adequately alleged a competitive injury. The court would do the lower courts a favor if it adopted a cleaner rule recognizing the obvious standing of candidates to challenge allegedly unlawful rules governing elections. So it's always been sort of understood that federal candidates had standing. It's just been recently an issue. So we're very hopeful the Supreme Court's just going to clear that up in a paragraph, and so we won't have that issue anymore, but who knows? We are fortunate that we have one of, if not the best conservative Supreme Court jurist arguing our case. His name is Paul Clement. He's very famous in my world. He's argued over 100 times in front of the Supreme Court. He's from Wisconsin, so he's a Midwesterner. Next slide. Okay, so that was the Supreme Court case. We can, again, talk about that a little bit more with question and answer. And now I'm going to talk about voter rolls, cleaning the voter rolls. It's all over the news, as we know. I'm sure, I would think a lot of you saw what's going on right now with the Civil Rights Division of the Department of Justice demanding the voter rolls from the Illinois State Board of Elections. We're going to get to that, but I just want to give you a little background about a couple of federal statutes. The first is the National Voter Registration Act of '93, the NVRA, otherwise known as Motor Voter. This was passed during the Clinton years, try to make voting easier for people. They just sign up at the DMV. We all know all the fraud that can lead to. Next slide. So what does NVRA do? Requires states to conduct a general program that makes a reasonable effort to remove from the official voter rolls the names of ineligible voters who have died or changed residence. The law requires registrations to be canceled when voters fail to respond to address confirmation notices and then fail to vote in the next two general federal elections. Next slide. Then we have, and this is in the aftermath of Bush v. Gore, the Help America Vote Act of 2002. As we know, there was all this controversy regarding voting machines and uniformity of voting machines, and we need federal voting machines. So that's what this was about. But it did do a little bit more than that. It established the U.S. Election Assistance Commission to set, voluntary guidelines for voting equipment, to promulgate and manage the National Voter Registration Form, to serve as a clearinghouse for best election practices. Next slide. This is just sort of a thing that I think is really fun about Judicial Watch. I don't know if this is the right place for it, but they have analyzed voter registration lists all over the country and, filed lawsuits, legal actions. It has resulted in the removal of 5 million names from the voter rolls. Okay. So Judicial Watch, they don't rest very much. So they chose to sue the State Board of Elections for not cleaning up the voter rolls properly, and they themselves are a plaintiff. Breakthrough Ideas, Illinois Family Action, Carol Davis, suing the State Board of Elections. Next slide. So this is really technical and kind of geeky, but two main violations of the NVRA: failure to make reasonable efforts to remove ineligible voters from the rolls, failure to maintain and to make available certain records concerning voter list maintenance activities. Next slide. So guess what? Guess what comes up again? Standing. That our old friend. So this is kind of interesting. We made the arguments for standing. You can see them here. Carol Davis and Judicial Watch have standing as voters whose confidence in electoral integrity is undermined. Judicial Watch has informational standing. Next slide. And you have to make, as I said, those economic injury arguments. You have to show that you've been economically damaged. So here are arguments. Breakthrough Ideas, Illinois Family Action. They purchase voter lists derived from Illinois' official voter list. Inaccurate voter rolls cause them to waste money. They must divert resources to less effective communication methods. These injuries are concrete and directly traceable to their violations. You guys, I know you're going to love this slide. We cite data showing that 23, this is in our lawsuit, this is all public, 23 Illinois counties reported removing 15 or fewer registrants under the notice and waiting period procedure. I believe Kane County is one of them.
Kane County is part of the 19.
Yeah, okay. Oh, part of the 19, thank you. 34 counties reported no data, 19 counties reported no data on death removals. That's Kane's in that one. And we only have 103 counties. I mean, I don't mean to sound glib when I say that, but it's not that many. 22 counties did not report inactive registrations. Next slide. So the basic excuse for the State Board of Elections is, well, it's the county clerks and it's their fault. That's not a good enough argument. That doesn't hold water, and it shouldn't hold water in the long run. But we're still at the initial stages of this lawsuit, and we just about a month ago received a decision, an opinion from the judge, the federal judge, saying that Judicial Watch and Carol Davis do not have standing. The other plaintiffs do, but we don't even have a written ruling. I couldn't even explain to you why she came up with that logic because she hasn't provided it to us yet. She just wrote a minute order, just a 2-sentence thing saying that. We don't know the rationale behind it yet. We will get it at some point. We can skip this. Okay, so are you all familiar with President Trump's executive order? Yes. Have you all heard about that? Yes. I thought that was very interesting. March 25th of this year, he signs an executive order to protect the integrity of elections. The Election Assistance Commission will require documentary government-issued proof of citizenship on its voter registration forms. Agencies like DHS, SSA, Department of State must provide states with access to federal databases to verify eligibility and citizenship of individuals. The Attorney General will prioritize prosecuting non-citizen voting and related crimes, including through the use of DHA records in coordination with state attorneys general. Next slide. So then, even more recently, the Civil Rights Division of the Department of Justice, and this is led by Harmeet Dillon, who we all see on TV a lot. I actually had the pleasure of having dinner with her a couple weeks ago in Nashville, along with 100 other people, but that was a lot of fun. She is writing to almost every state, blue and red states, demanding the voter registration database, including sensitive information, and there are exemptions for that if it's just, like in a lockbox kind of a thing. So they're going back and forth on that currently, and this has been in the news. So this is just their fight, meaning the Illinois State Board of Elections is fighting with the Department of Justice over what they're going to release, redact. Well, that's a stay tuned type thing of what happens with that. This is Harmeet Dillon's letter. Must contain all fields, including registrant's full name, date of birth, residential address. Okay, next slide. All right, so my favorite topic actually is the freedom of speech topic. I didn't do slides on it. I apologize for jumping to all these topics, but I think this is a really important one for us as citizens. My client, Jeannie Hedgepeth, really wanted to be here tonight. She's a Palatine High School teacher. And again, I'm able to divulge to you all what is in the public domain. This is all public information. She had foot surgery last week. Otherwise, she would have been here tonight. And she and I were going to do a little back and forth about her case. But I will just sum it up for you in a nutshell, because this should outrage you all as U.S. citizens, as government employees, and the like. So Jeannie was a Palatine High School teacher for 20 years. She served very commendably. She was revered by her students. She was very open. She taught the women's studies class and just really opened up her students' lives and minds to all these different perspectives as a teacher, and she was very proud of that. So May of 2020, who remembers what was going on in the country in May of 2020? So the school year had ended at Palatine High School. She was on the beach in Florida, and she went on Facebook complaining about the rioting and the looting in downtown Chicago, which was a very scary thing for everybody. And then she went into a little bit more so a really interesting philosophical discussion about what causes a lot of different things. I mean, these are, you could say, controversial topics, but she was quoting conservative black leaders about the fact that, or at least their theories about why there is crime in the black community. And again, these are issues that we could delve into, but they're issues of public concern, right? And her posts were considered very provocative. And at the end of the day, District D211, which is the Palatine-Schaumburg area, they fired her because they didn't like her speech. They just didn't like what she had to say. They have excuses. Their big excuse is that she caused what's called a disruption to the school district that was so great that they shouldn't have to tolerate that sort of speech. But as we all know, government employees have free speech rights too, just like the rest of us. And we feel that her free speech rights were trampled upon. She was speaking about a matter of public concern. She was off work in the summer on a beach in Florida, and you get fired for that. And I mean, we lost in front of the district court. Just yesterday, we got bad news from the Seventh Circuit Court of Appeals. We have to figure out where we're going to go with this. But again, it's a trend going on throughout the country with government employees. We'll see what we can do with it. We may have, again, the good old circuit split. We've got a Seventh Circuit decision. There's decisions to contravene that in other circuits. But again, to get the Supreme Court to take that case, we'll cross our fingers. So with that, I know that was a little bit dry, but I would love to hear questions from you all.
I just wanted to add one piece to what you said. Yesterday, Representative Brian Stile, he is at the congressional level, and he is the head of the federal elections, what you referenced. And so he's the one that oversees all, I don't want to have my back to someone. He's the one that oversees all of the elections, and he just made a statement that, similar to what President Trump has said, that universal mail-in ballots they want to end before the midterm elections. So he just posted that, and so it's out there. Obviously, it's going to take some work to end that, but that's going to be, President Trump said it, and then now he said it yesterday. So he's on the administration, and he's the chair for the committee for administration. So just like you hear other chairs of different, he's the one that's the chair for that. And then the other thing I wanted to let you know, just to give you a little information, someone that Carol and I work with is Willard Helander, and she's over our state voter list maintenance. And I just spoke to her on Sunday night, and there are over 400,000 names that have moved out of Illinois, 400,000 that have not been cleaned off the voter rolls. In Kane County, we have 12,592 voters, and in Kane County that have moved out of the state. So that's something that we're working on. Like Christine said, the county is saying it's the state. Everybody is pointing fingers at whose job it is. And so we are working. We have a group, Willard meets every Monday night, and they try and to clean out the voter rolls. And we have some ideas of some projects that we might be working on, and I may be sharing that soon because we'll need volunteers to help with that. So anyway, just wanted to give you some statistics. We do get a monthly, the Illinois Republican Party requests a list from the State Board of Elections that we have to pay, the Republican Party pays for, and that list is how we know where we're at, and we check it every month against to know like where our numbers are. So that was, I believe it was as of last month. We just got, we get it the 15th of every month. So I'm not sure if it was as of July 15th or August 15th. So, questions? Yes.
So I noticed that the issue of standing came up a lot after the 2020 election. It's very common. Do you have any thoughts? Well, there's another thing too. In all the court cases that we saw, many of the court cases with Trump and his affiliates, the judges would not allow the defense to show their evidence. Like they just said, no, you can't show that in court. Now, do you have any thoughts on whether they were judge shopping, got some ideological bedfellows on a kind of a mass scale, or did it come down from high? We're not doing election cases, find a reason to dump them. Do you have any theories on how that is so widespread just with the election and the Trump affiliates and Trump? So
you're talking about in 2020, the judges not being willing to hear election evidence about the voter fraud that happened during the presidential election?
And then the lawfare against all the Trump, the wider, it seemed a lot of J6ers were not allowed to present their defense evidence, that the judge said, nope, we're not hearing that. And it just seems like there's a conspiracy, or they're judge shopping, got lucky. Do you have any theories on that?
Well, you can't really judge shop in federal court, so you're sort of stuck with the judge. But it is within the purview of the federal judge to decide what evidence is going to be brought forth. So I do have some theories about the cases that were brought in 2020 after the November 2020 election. I don't necessarily know that the best legal arguments were made at the beginning. Quite frankly, I also don't know that President Trump had the best lawyers at the beginning. I'm talking about the first week or the first couple weeks. Right. So sometimes, and this did happen in a few states, our opportunity was lost because of some bad lawyering. And then you're sort of stuck with that decision, and it's hard to fix it. I think that happened a lot, or may have happened.
Okay. I can tell one thing. I happened to be with Pam Bondi, lucky, just a chance. She was up in Wisconsin. And she said that the issues, what they learned from 2020 is it's very, very difficult to win elections or to win cases after the election. And I'm guessing maybe you've seen that as well.
Absolutely.
What she said is, this was when I saw her was last October of 2024, and she said that's why they had like 20 cases or more. I don't know the exact number, but there was a lot of cases they were pursuing before the election because they had a better chance of winning things before. And so that was something that she had said that
100% true.
Yes, yes.
Chris, the issue of standing was very central to our case, as you recall. I think I read a few weeks ago that Congress is considering a measure to give citizens standing in sanctuary jurisdictions.
I did not know that.
And that kind of relief would apply to standing and other issues as well.
One would think that's a really interesting concept, and I have not heard that.
But the two-thirds rule in the Senate might make it impossible.
Right.
The other thing is your controversy in Evanston. Are you going to talk about that? That's a rough one, I know.
Yeah, I prefer not to. I mean, for a variety of reasons. I just don't want to go too far off topic.
I shouldn't have put you on this.
No, that's okay.
I heard of a couple of cases where ballots were received in the 2-week period after the election that affected otherwise close or contested races. And the question then is, how do we know that the postmarks are being validated in these cases? Do we know that? So
I myself have been at the Cook County Circuit Clerk's office after Election Day, and half of the envelopes don't have postmarks. I saw it. And if they don't have a postmark, they go to the date of the signature on the envelope. which is before Election Day. And that's actually the law in Illinois. And the post office, I mean, we all know what a disaster that is. And so, again, it's all by design. It's built into the system. The post office, I mean, they claim, oh, we just can't get around to postmarking things, but it's a good excuse for more ballots to come in.
There's your answer. Another, Carol? I'll get you next.
Thanks.
Uh-oh, my client's going to trick me. Just watch. Stop me, I should say.
No, I just admire you so much, and thank you so much, Christine, for all the work you've done. Christine and I go way back. She's been fighting this battle for many, many years alongside a lot of us. So my question is, what impact do amicus briefs have when we're trying to get things before, and is it only the Supreme Court, or would are amicus briefs ever presented to the like Seventh Circuit or anything like that? And because when with the Bost case, Russ Noble put out the call through our network, because we've got so many people involved, for different organizations to file amicus briefs, with the hope that it would catch the Supreme Court's attention more. So I'd love to hear your thoughts on the whole amicus brief issue.
No, that's a great question.
Maybe explain what an
Sure.
amicus brief is.
So amicus brief means friend of the court brief. Friend of the litigant, really. Amicus means friend. So I guess you are sort of filing as a friend of the court. I guess that's correct. It's a Latin term. So I don't think that I've ever seen it at the circuit level. It may exist, but so I may be wrong about that, but I've never seen it. Supreme Court, it's extremely common, and it's extremely powerful, and there's a reason to do it, and that's exactly why. It is powerful and persuasive, and I think it's a great thing that you did that. And I mean, I think that they read every one of them, and it's very often that you see in Supreme Court jurisprudence where the amici brief is quoted in the decision. So they absolutely read it and they absolutely consider it. So that's my answer.
Which justice is over District 7?
So it's Amy Coney Barrett. Now, that actually is, believe it or not, irrelevant to this situation. I'll tell you why. So all those circuits that I mentioned to you, there's 13 of them. One is the district court for the federal court, so that's just out there in DC, but the rest are the 12 that convene around the country. So each of the 12 has an associate justice or the chief justice associated with that circuit as like a go-to, as a liaison, if you will. So in the Seventh Circuit, it's Amy Coney Barrett. Now, the reason why I say that's irrelevant is because that really only comes into play when there are emergency petitions filed. So Amy Coney Barrett, if there were some, and there are, I mean, we just had, oh, good Lord. I can't remember off the top of my head, but there were some emergencies, when were they? Just a year ago. It escapes me. But when emergencies come up, that's when it's relevant who the associate justice is affiliated with the circuit. Because if they are, more friendly to your cause, you have a better chance of that emergency being pushed up to the court. But as far as the court taking it, it's not because of Amy Coney Barrett at all, meaning the whole court taking our case.
So who makes the decision for the seventh? Because you said they denied it. Who makes that decision?
So when you said they deny it, what do you mean?
I thought you said the seventh court wouldn't take it. Circuit court.
I'm a little confused. So
maybe I misunderstood.
Let's see.
So the seventh court, you said denied, right? Circuit court denied?
The Seventh Circuit didn't agree with our arguments.
Yes.
And so we had one justice, I didn't mention this part, Michael Scudder, who dissented from the majority. It's a 3-judge panel at the Seventh Circuit. So 2 thought that we didn't have standing. Michael Scudder did. Judge Michael Scudder. He didn't think that, this is an aside, that Susan had standing, but he thought that Congressman Bost had standing as a federal congressman. So again, we lost to the Seventh Circuit. Now, when we appealed to the Supreme Court, I believe, they convened, the 9 of them, to decide what cases to take. I don't know if that's done by a 5-4 vote, 6-3 vote. I don't really exactly know. They have their own numbers, as I said, between 70 to 100 a year, so I'm not quite sure how that process works. But the whole Supreme Court decides whether or not to take a case from one of the circuits. Does that make sense?
Anyone else with any questions? Oh, Carol again. Sure. No, it's great.
Maybe.
So, oh gosh, I think my question just slipped my mind.
It's easy to do.
I may be biased, but your argument on the voter rolls seems pretty clear as to how the outcome should be. What was the reason that the original court that you went to said that that there was no merit to the case?
On the voter rolls case?
Yeah.
Well, they haven't decided the issue yet. They've only said that we're in like the second inning on that case. So we lost on standing with 2 of our plaintiffs, but several of our plaintiffs are still in the case. But the case is in legal limbo because we're still awaiting from a decision from the judge. I mean, she just sort of like gave us like I said, a 3-sentence order. We are waiting for a full opinion. Then we proceed with the case. So the case hasn't been dismissed or denied. That was just like a procedural thing that we're working through.
Carol, you ready? Yeah, I remember. Sorry, I've got so many things going on with this. So, on the Bost case, because I know it's confusing with these cases going on. So,
Yes.
Bost case. So I hear the argument's going to start October 8th. Now, we know the Supreme Court has like a season. They hear the arguments maybe for several months, and then they park themselves in an enclave and, like we're waiting for the Pope with the white
Exactly.
smoke. So will the Bost case be one of those that we don't really know what the resolution is until June?
So this is just speculation, conjecture on my part. I think it's an easy decision. I think it might be 9-0 or 8-1. And I think we're going to know before June of 2026. That's a total guess on my part.
Okay, pray, people, pray, because the standing thing, even if they don't rule on the merits,
And they won't.
now would they remand that then back to the Seventh Circuit?
To the Northern District of Illinois judge.
Okay, because if the standing issue, you and I know, the left always has standing, the right never
We
has
don't.
standing. That's what a clean.
That's why I read that paragraph of the relief that we're seeking. We want them to spell it out for everybody.
Yes.
You've got standing, make it clear so we don't have to go through this nonsense.
That would be so huge because, I guess what we could be praying for is if they hear the arguments and they make a decision quickly. See, I'm thinking 2026. If we don't hear their decision until June of 26, it's going to be the 14 days it's not going to matter.
We're too close to the next
Right,
election, right?
Right. But if they hear that early and decide on standing and it does get remanded back to the 7th, there might be a very slim chance that we could do away with the 14 days of ballot counting before the 26th election.
I'm really cautiously optimistic, but it's anyone's guess.
If you're praying
I love your thinking.
If you're a praying person, please pray.
What is the date you're going to be before the court?
October 8th.
So it's early in the year.
And
Everyone is in the fall, though. Well, they schedule all the cases for argument in the fall.
And will you be there helping Paul? Is that the idea?
So yes, so I'm lucky enough where I get to attend as local counsel. So Paul will be obviously making the arguments. We have other attorneys that have done more work on the case that I have. We'll probably get to sit at counsel's table. So I don't know if I'll get to be at counsel's table, but I'll still get to partake. Susan's going to be there, by the way. She's going to go with me. We have to plan our outfits, meaning our St. John Suits or whatever the case may be.
Who's the district court judge in the Northern District?
So it's interesting. It's John Ness. I graduated from college with him at same year at Northwestern. And he's a Federal Society attendee. Kind of interesting.
Does anyone else have any questions? No questions? I would like to add one more thing in reference to Harmeet Dillon, because I'm sure Carol can agree to this. When we're for the state voter list for that information, when we get it, you would be shocked. So each of us have a state voter ID, and would you believe every single person in this room has a state voter ID? And what happens is when we request the list, a lot of times they're missing. And so then you have to go back and find out why they're missing. And it becomes a very complicated. And so I was very pleased to see Harmeet asking for all of the information, because they conveniently leave out a lot of that information. Because that's the way we can track to know Debbie Kenarowski moved from Geneva to Park Ridge, is by that state voter list. So it's really important, that information that she's requesting, and that is going to be a fight, because we fight with the State Board of Election and our clerks on that information on a regular basis. Unless you ask for that, a lot of times they won't even give that information. So go ahead.
I just want to say in our, at the Kane County Public Service Committee meeting that we had in August, the guy that represented the clerk's office said that they follow the law. So I'm just saying we need to nail them to the wall on it.
Yes, Mr. Pollack, he is a Democrat. And a lot of times he won't say anything when we go and question him. When we were fighting with him, he won't say. He says he refers to Jack, but Jack never attends those meetings.
I was an election poll watcher or election judge in the basement of 69 West Washington in 2014 at the last day of counting ballots. And on election day, the Republican treasurer had won the race by 5,000 votes roughly. And we counted 35,000 provisional ballots that day. 99% of the affidavits on the outside of the provisional ballots were blank, which means the affidavit is blank, you're supposed to throw it away, not count the vote. They counted all the votes. 99% of the ballots contained one vote only for the treasurer's race, which is kind of weird. But they counted, and at the end of the day, the Democrat won the treasurer's race.
That's strange.
Thank you so much for coming.